Hello, I am Kathryn Hollingsworth and I am a Professor of Law and Criminal Justice at the University of Sheffield. And in this video I'm going to be speaking about children, sentencing and communication. I'm going to start with the Court of Appeal decision in the case of ZA against Crown. Now, this was a landmark decision in relation to sentencing children handed down by Mrs Justice May in the Court of Appeal, which explained that sentencing children requires a root and branch difference of approach from cases that involve the sentencing of adults. And this requirement to take a root and branch difference of approach applies not only to the way in which we calculate the sentence itself, but the way in which the court communicates that sentence to the child. And that's what the focus is going to be on today, on how important it is the way in which the judges communicate sentences to children in a rights-respecting manner. And we can see that when judges do this, it can help to promote effective participation. It can help to children to perceive the system as more legitimate, and it can help to support their reintegration. Perhaps more importantly, I would like to suggest that a rights-respecting approach to sentence communication may also have a legally transformative impact. And what I mean by that is that it may also influence the substance of the sentence as well as the way in which the judge communicates that sentence to the child. So in this presentation, I'm going to talk a little bit about the current research context. I'll talk about the legal framework. I'll then move on to speak about a study that I've conducted into children's experiences of communication within the sentencing context. I'll then talk about a few of the resources that are available and some examples of best practice from the courts. And then I'll finish with a few practice points for legal representatives or lawyers. So turning first to the research about children's knowledge of sentencing. I'm going to start with a study that I completed last year with the Sentencing Academy, and this was a large-scale survey of children as a general population in England and Wales. So we surveyed 1,038 children aged between 10 and 17 who are living in England and Wales. So this is children over the minimum age of criminal responsibility but below the age of legal adulthood. And it was the first large-scale survey of its time to ask children what they know about sentencing and what their opinions are about sentencing. We also asked a few preliminary questions to check their general understanding, and this was kind of acts as a bit of a benchmark to what they know about criminal justice. So one of the things that we asked them was about the minimum age of criminal responsibility. And what we found was that only 27% of the children were able to identify 10 as the correct age of criminal responsibility, and that 61% of them thought that it was higher than 10, and that the remaining percentage thought it was either lower or they didn't know. So 61% of children think that the minimum age of criminal responsibility is 10. In addition to that, we also found that 30.5% of them thought that the minimum age of criminal responsibility was higher than their current age. So in some ways, if an 11-year-old thinks that it's, or if a 12-year-old thinks that it's 11, it doesn't matter. They know they're subject to the criminal law. So what we were interested in is how many thought it was higher than their current age. And we found that almost a third of them did not know that they were subject to the criminal law. And I think this is significant because it tells us really that's quite a clear, easy piece of information for children to retain in a way. And so if they don't know the minimum age, then we can expect low levels of understanding about other rights that they may have in the criminal justice system or their knowledge about sentencing per se. We checked their knowledge about sentencing as well by designing a couple of vignettes, scenarios, that involved a character, and we explained what the facts were. And we asked them what sentence they thought that the court would hand down. One of these involved a 16-year-old defendant who was convicted of his second knife crime, and it was taking a knife into school, taking a bladed article into school. And 57% of the respondents thought that child would receive a non-custodial sentence, whereas in actual fact they would probably receive some mandatory sentence of a 4-month detention and training order. So most of them thought that a non-custodial sentence would be handed down, but in fact the child would be, in that scenario, would be likely to go to prison. So I think it shows us how limited their understanding is there and what their expectations might be if they were to come into the system themselves. We also found that 57% of children thought that judges do not understand what children's lives are like now. So they think judges are out of touch with what it's like to be a child. And I think this is important because it shows the low levels of knowledge they have about the criminal justice system. It shows that their expectations may be out of line with what actually happens. And it shows us that they perhaps have low levels of trust that judges will understand them and understand their lives as a child. So it's a very broad snapshot, but I think it highlights the importance of communication, including of how lawyers communicate with child defendants, but also that communication that's taking place in the courtroom in terms of helping the child to understand what's happening, not assuming that they have any prior knowledge, helping them to understand and anticipate what the outcome might be, and helping them to understand the outcome when it is handed down. Turning now to the research specifically on children who have been through the criminal justice process, and in particular children who we see being sentenced in courts. So first of all, just to kind of give some background context about these children, we know that this is a very vulnerable cohort of children. We know that many children in the criminal justice system are going to have additional needs and vulnerabilities, and are certainly going to be more likely to have additional needs and vulnerabilities than children outside the criminal justice system. In particular, we are increasingly aware of instances, experiences of trauma, and that children who've been in the criminal justice system may have experienced bereavement, they may have been victims of crime, they may have been subject to parental neglect or abuse. And that trauma may be a reason for their offending, but it also may impact on how they experience that communication within the courtroom and how they behave in the courtroom. We also know that there are a variety of needs that children have that stem from the socio-economic context within which they have grown up. So a Ministry of Justice and Youth Justice Board's report from 2021, looking at the profile of sentenced children, found that there were safety and well-being concerns for 90% of them, that 68% of them had learning, education, training and employment concerns, mental health and physical health challenges, and an additional, a different report in 2022 that from the Department of Education and Ministry of Justice found that 80% of cautioned or sentenced children had a special educational need. So we're seeing this profile of children with additional vulnerabilities and complexities in their lives. And we see this recognised in the overarching guideline principles for sentencing children and young people, published by the Sentencing Council in 2017. And this is the kind of go-to, the overarching sentencing guidelines that judges should be referring to in any case that's involving the sentencing of children. And we see them in that guideline, this clear articulation at paragraph 1.13 that these factors are regularly present in the background of children who are coming before the court. And various studies across different cohorts of children, across different jurisdictions, also show a very consistent picture of speech, language and communication needs amongst this cohort. And again, much more than you would find in the general population of children. And there are various different studies, but if we just point to, for example, the children who've been sentenced, this MOJ report from 2019-2020, we see that 71% of those children have a speech, language and communication need. And we see an estimation of reports published by Brian and colleagues in 2015 that we're looking at somewhere between 62% and 90% of children in the criminal justice system with an additional speech, language and communication need. And that compares to about 10% of children elsewhere. And so we see that if we think about the really high level of communicative skills that are required when children are in court, they need to pay attention for a long time. They need to follow complex language and process information that may be non-literal. They need to give coherent narratives and accounts of their events in the correct order, particularly if they're giving evidence. They need to be able to instruct their lawyer. They need to be able to understand the sentence, of course, and they need to understand what they are communicating to the court through their body language as well. And these are really sophisticated levels of communication skill that are required. And so, given what we know about children and their communicative abilities, and particularly many of those children with additional vulnerabilities, we can well understand, I think, this conclusion that Sauerbutt and colleagues have got to, that there is a fundamental mismatch between the communication requirements of the youth justice system and the communicative abilities of many of those who encounter it. And one of the particular difficulties is that those who do have a speech, language and communication need, about 92% of them, according to a relatively old study now, but it probably hasn't improved that much, are undiagnosed before they enter the justice system. And so for lawyers who are dealing with children and communication, it can be very easy to miss the communication needs that they have. They may not have already had a diagnosis, for example, from school or elsewhere, and children can be very equipped at masking the difficulties that they face, for example, by repeating words or phrases that have been used by the person that's asking them the questions, by giving stereotypical answers, or of course giving affirmative answers where a yes-no question is asked of them. So it can make it very difficult for both lawyers and also for judges to identify that a child has a speech, language and communication need. We also know that there is going to be a high prevalence of other disabilities which may coincide with a speech, language and communication need or come with additional difficulties as well. So we know that many children in the criminal justice system will be neurodiverse, so they may have ADHD or autism. Now the exact statistics on this are quite complicated, and in part this is because different terminology and different criteria is used by different professionals, so health, education, criminal justice and so on. And partly we don't really know because of poor screening and because of this kind of co-occurrence between special educational needs and neurodisability, for example. But in general, in the criminal justice system, it's thought that about a third of children are neurodiverse, and adults, in fact. And of the common disabilities that we see in the criminal justice system, I've just included this table here that was compiled by Claire Parkinson, who is a speech, language and communication specialist, and it's included in the Crown Court Compendium, which I will refer to again later. And it just talks about, this table just sets out really some of the key disabilities that we see in the criminal justice system amongst children and how that may present in terms of a description of need, particularly in relation to communication. So how they learn, how they think, how they perceive, how they act, and so on and so forth. So that might provide a useful resource. But again, it's difficult to know that these children have it, but it can be really crucial. It can really impact on juries' assessment of a defendant. So we know from studies with mock jurors, so kind of replicated cases. We can't do actual research with actual jurors, or only in very limited ways. But with research with mock jurors has found that where jurors are told that a defendant is on the autism spectrum, that they are provided with background information about that condition, they're much more likely to see the person as less culpable and as believable, as a reliable witness, and they're less likely to reach a guilty verdict. Now, I'm not aware of any research that has been done in terms of magistrates' knowledge, for example, but I think we can see that perceptions of culpability, perceptions of remorse and so on will be affected and could affect sentence if a child's neurodisability is not identified. So it's really important that we know what's going on for that child. I just also I think it's really important for us to remind ourselves, I think this is very familiar, but just to remind ourselves of the extent of disproportionality in terms of ethnicity for children in the criminal justice system as well. We see from the statistics here and set out on the slide that there is a massive overrepresentation of children from black children or children from mixed ethnic backgrounds. And that whilst the numbers of children in the criminal justice system overall has decreased, the numbers of children in custody has decreased, disproportionality has actually got worse. And the reasons for that are there's multiple reasons why children from black and mixed ethnicity backgrounds are overrepresented. Partly it will be the relationship with other factors, so they may have been excluded from school already, so that kind of embedded racism and institutional racism in other contexts. They may be more likely to be living in poverty. They are more likely to be care experienced. So those factors which may already increase the likelihood of offending or being brought into the criminal justice system will be overrepresented. They may have experienced discrimination earlier in the system, so for example, in relation to police stop and search. We know from the Lammy report a few years ago that black defendants are much less likely to trust the criminal justice system and the actors within it, and therefore they're less likely to plead guilty, so they don't benefit from the plea reduction. They don't benefit so much from diversion earlier on that's dependent on admission of guilt. Remand decision making is really subjective, and that leads to more restrictive remand outcomes for black and mixed ethnicity children, with a focus on their perceived risk rather than the offence that they have committed. And if they've been on remand, they're probably they're already going to be in a custodial institution, and that the negative impact that has on them. And then, of course, we have an increasing recognition of the problem of what is called adultification. So just turning to this slide with the definition of adultification, it's a form of bias where children from black, Asian and minoritized ethnic communities are perceived as more streetwise, more grown up, less innocent and less vulnerable than other children. And this particularly affects black children who might be viewed primarily as a threat rather than as a child who needs support. And this is really important because it can affect how the child is spoken to in court by the judge. There may be an overestimation of the child's communicative abilities if they are perceived as more mature than they actually are, as well as that kind of the communication, the subtle tone that can be quite damaging for children's perceptions of legitimacy. It can affect perceptions of their culpability or their blameworthiness and so on. So something that does intersect with this really important thinking around communication and the need for an awareness of the impact of this on courts. And we also know, of course, that many of the children in the criminal justice system will be care experienced. So 59% of children in custody are care experienced. And that compares to only a small number of children outside the criminal justice system who have been in care. And we also know that the custodial sentences for black and mixed ethnicity children who are care experienced are twice as common as it is for children who are white and care experienced. So we're seeing this kind of layering of disproportionality and discrimination for black children who are also in care. And again, the reasons why care experienced children are criminalised is because, of course, their behaviour in care settings may be more likely to be criminalised than it would if the same behaviour in a family home. They're more extensively subject to surveillance. They're more likely to be targeted by the police or targeted by criminal gangs. They might be living a long way from home without family support. The reasons that led to them being in care obviously are going to be related to neglect or abuse or bereavement or some of the challenges in that family context, which may lead to difficulties for them that result in offending. So all of which is just to emphasise this group of children who are have high levels of vulnerability, high levels of need, and a real need for support, including support in terms of their communication in court. So, we're really, it's just really important to have all this background context in mind. But it's not just the additional needs that some children have, and the majority of children in criminal justice have. We also need to remember even those children without an additional speech, language and communication need, without an additional disability, who are not care experienced, etc., they are still different than adults. We know so much more now about adolescent brain development. We know that the adolescent brain continues to develop until our mid-20s, and that can affect impulse control, it can affect reasoning, decision making, empathy, remorse, planning. So all of this can impact what the child's communicating to the court, as well as how it led to their earlier offending and how their behaviour in court. But also it affects their own participation, their understanding in court as well, their ability to concentrate, and so on and so forth. So that's the kind of background that we know from the kind of broader research, the quantitative type research about the types of children in the criminal justice system. Now, just turning to the law and communicating sentence in court. Now, the starting point really is the overarching, the definitive guidelines for sentencing children and young people, these overarching principles. And although these overarching principles are designed to apply to the substantive sentence, they should, I would argue, also apply to the way in which the sentence is delivered. So the principal aim of the youth justice system is to prevent offending. So how can the sentence be communicated to the child in a way that helps them to prevent offending? Courts must have regard to the welfare of the child. How can we ensure through the sentencing hearing, through that communication, that the child's welfare is at the forefront of the court's mind there? Effective participation, protected under Article 6 of the European Convention of Human Rights, absolutely central to communication, to the child's ability to understand what's happening, to understand the outcome. We know in the UN Convention on the Rights of the Child that the best interest of the child should be a primary consideration. And we know that custody must be used as a last resort, and that there must be a focus on the child's reintegration. So how does the way in which the sentence is communicated ensure that the child is best able to be reintegrated into society? So I would suggest all of these principles set out in the guideline are also relevant to sentence communication. But in addition to that, there are specific legal obligations on the court at both a sort of international level, but also in the domestic law. So we know that there are really clear obligations about the need to secure effective participation for children to ensure that they are heard throughout the proceedings. So we see this set out in General Comment number 24. We know it's in Article 6 of the ECHR. And we also see specifically in the criminal procedure rules that before passing sentence, the court must give the defendant an opportunity to make representations and introduce evidence relevant to sentence. In terms specifically of how that communication happens, or what it looks like, we know from the Criminal Justice Act 2003, Section 174, requires the court to give reasons in ordinary language. Now, what's the court's ordinary language might be very different from what a 15-year-old child's ordinary language is, but it has to be ordinary language. It shouldn't be legalese. It shouldn't be complex. And the criminal procedure rules require that the sentence must be communicated in a way that can be understood by the defendant. And we have seen an increase. We've seen a couple of really key decisions in the Court of Appeal in recent years. So the decision in Chin Charles from 2019, that was an adult case, but there the court really emphasised that the offender is the first audience for the sentence, not the Court of Appeal, so there shouldn't be references to cases. The court should be talking directly to the defendant. And then again, ZA that I referred to earlier, that sets out that when sentencing a child or young person, this requires the court to explain the sentence and the reasons for it to them, to the child, in a way and using language that they can easily grasp. So those are the requirements, quite clear, both from the Court of Appeal and from the legislation and the criminal procedure rules and the sentencing children and young persons guideline, that a lot of focus has to be on communication, and it has to be communication that children understand, that is positive for their welfare and their well-being. What I want to look at now is what actually happens, or what children say happens, and how they feel during those sentencing experiences. So a consistent theme that emerges, and this is data from a research project I undertook, where I did in-depth interviews with children who had experienced the sentencing process, and also the Howard League for Penal Reform shared with me data that they had collected from children in custody about their experience of sentencing. So these quotes are drawn from those sources. And what we see here, what's really clear, consistent theme across all the research, is that children do not understand the language that is used, and the impact of that is that it alienates them and it makes it much harder for them to participate. Research has been carried out with adults by Jacobson and colleagues in a really excellent book called Inside Crown Court, found that communication, both verbal and non-verbal, was a really key factor in creating what they describe as an us and them culture within the Crown Court. So for lay people on the one hand and the professionals on the other, so lawyers, judges, and so on the other side. And that the use of language was really alienating to them, and that it emphasised social and educational differences and so on. And as a result, that made participation harder. And what we see for children is that it's not just this division between lay people and professionals, but also this additional age difference between them. So they perceive the language as being language that's used for adults. It's not language that young people can engage with. So there's also this age-based division there. And that confusion, that lack of understanding and their lack of ability to participate is exacerbated where they are experiencing anxiety and stress. And of course, children in sentencing are feeling very stressed. This often can carry really important consequences for them, particularly in the Crown Court or where they might be facing a custodial sentence. And this word cloud here is a collection of the words when I asked them, my interviewees, how did you feel during the sentencing hearing? These are the words that they used. So we see that it's a very stressful situation. And the other side of that is that when children have communication difficulties, they get more stressed and anxious in those environments where a lot is being demanded of them. So it's this vicious circle in terms of stress and communication. So welfare, well-being certainly not being placed or addressed adequately within that context. And this has a huge impact. We see this here from 13-year-old Samuel in the Crown Court, that he was really nervous, and you really get this sense that he does not have a clue what's going on. It was just quiet, then talking, quiet, then talking, quiet, then whispering. He couldn't tell me anything that actually happened. He just did not understand it. And for Marcus, it's this real sense of being on the outside, being powerless. So, there's people talking about you in front of your face, but you're just standing there and you can't do anything. So this real sense of exclusion and certainly nothing that resembles what we might consider to be participation here. So although it may appear to judges or lawyers or magistrates that a child is understanding, maybe they're nodding, maybe they're looking like they're engaged, this is probably not going to be the case for many of them. And they're probably feeling also inside very stressed and very anxious. And this is important because, this can impact then on how children perceive that system. And we saw that, that use of language that they feel is exclusionary really impacts on their sense of fairness. And that we know from a lot of research in this area of what we call procedural justice, that where individuals perceive the system to be fair, it increases their perceptions of legitimacy. So if they feel they've had a voice, they've had a say, and if they perceive the decision maker as neutral, and if they feel they have received fair treatment, they are more likely to trust the decision maker and they've been treated respectfully. This increases perceptions of legitimacy. And that in turn can help to increase the possibility of rehabilitation. So the flip side is we see this study in Australia of young people that where they felt stigmatised or alienated during the court hearing, they were substantially more likely to reoffend in future. So we want to see language that is inclusive. We want to see language that shows the child understands, that the child's views have been heard, that they are being treated respectfully, and so on. And in my research, I read all of the vast data that came from the interviews with the children, and I sort of identified 3 key elements that really contributed to children's perceptions of legitimacy that related to the communication in the courtroom. And I use the overall heading of kinder or kinder justice to capture these 3 aspects of legitimacy in relation to communication for children and communication of the sentence. So I'll just speak about each of these in turn. So first of all, I'm using kinder as a verb. So the communication of care or communication of kindness was really important to children. And this was 3 senses in which that care could be communicated to them. And this reflects the procedural justice literature, really, that children value judges who communicate verbally and non-verbally, that they have, first of all, taken care over the decision-making process. They've listened to the child, they've taken into account what the child has said, they've told them the other information they've taken into account, for example. They value judges who were demonstrably caring towards the child in how they treated them, a small smile, respectful treatment, but something about it was more than respect, it was also genuinely showing care about the child, treating them in a careful way. And then thirdly, they valued judges who showed care about the child's future and took account of the child's past, understood the child's past, the difficulties they had faced, and also were invested in what happens to the child in the future. So they were really important to the child. So just to unpack that a little bit more, they really valued where judges expressed hope for the child or conveyed hope. So Marcus here says, let them know they've made a mistake, but there is a chance that they can make yourself better. Like, give them hope, don't give them fear, give them hope. Or Andrew talking about the importance of authenticity, that when I read to them examples of sentencing remarks, and one of them was a very positive example, kind of best practice, if you like. And Andrew says that judge, I really think that was him speaking from his heart and him really telling everyone the truth about how he felt. That was really important, this sense of authenticity from the judge and authentic kindness. The judge conveying understanding, as I've said. So we see Grace saying, he read like he actually cared. And, he could, when he was reading, you could see he was understanding a bit more. And we can see the impact on this. She started to feel good. She was still upset, but finally someone is starting to understand her. And just how powerful this was, that was the judge in this case. And then we see Joshua emphasising the importance of empathy. That the judge has done the research himself. He's understood him. This judge is being more like he's saying, I'm a judge, but I've done stupid things too. And the judge actually says things like that in the sentencing remarks, that we all do stupid things. What's important is how we then, what we go on to do afterwards. So the judge is there breaking down some of those barriers and conveying empathy towards Joshua. And then we see from Lewis the importance of judges encouraging the child. So sentencing remarks that don't just set out the reasons for the sentence, but that give the child something at the end. So we see him saying, like, this the way in which the judge communicated that. So the judge talks about, the child wanting to be a mechanic and how he hopes the child can do that. And we say, Louis talking about how this is empowering. It's like, I'm on your side. I think that would definitely help. So that was the first sense, that communicating care to the child. Secondly, what was really important from my interviews was that children wanted to see in the sentencing process and in the sentencing remarks that their status as child, the fact that they were a child, mattered. For many of them, their own experience was that didn't matter. They were just treated just like an adult would be. And we see this reflected in Trent's quote here. At the end of the day, I'm still a child. It's like, when I was in that court environment, it didn't matter. Didn't matter whether I was a child or not, that's honestly how I felt. They wanted to see recognition that they were had greater vulnerabilities, that their background experiences, they might have had less control over them, they might have had fewer opportunities, they didn't have jobs. That's different than when judges were young. They wanted to see a recognition of the impact that prison would have on them as a child, and so on and so forth. So in terms of the communication, it's about telling them you're using we want the judges to explain that you're using simplified language and so on, so that they can understand. We want them to judges to think about the tone and how they're talking about young people generally. That there is this perception on the part of young people that judges think they're stupid. And a recognition that the vulnerabilities of childhood reduce their agency. They can't just move to a different part of the country if the area that they live in is one that is difficult not to get involved in gangs, for example. That they can't just move to a different school of their own accord and what have you. A clear articulation that because they are a child, they deserve a second chance, and clearly explaining that that the court, that we all owe them special duties because they are children. They have special rights because they're children. So I should say that also can be conveyed through the way in which a sentencing hearing is held, so making adaptations, judges removing their caps and their wigs and gowns, and the same with counsel if they're in Crown Court, or changing the layout of the courtroom and so on. And then the third sense of the way in which communication can really matter to children's perceptions of legitimacy was in terms of wanting to be seen in the way that their family see them, so kinder justice in that third sense. So they felt that judges always saw the worst of them, and that they don't recognise that version of themselves, that the judges talk in a way that is the worst version of you possible. But they don't feel like that. It's like when I'm with my family, they don't know me to be this person. So it's like, I'm not that person. You're trying to paint me like that person, and it's not fair. So they really strongly felt that they were not proper criminals, and they wanted to see recognition of this in the sentencing remarks as well. And this can be really powerful in terms of that reintegration side of things, that if they can see that the judge who has all this power, their perceptions that the judge is very powerful, can see good in them, that gives them hope for the future, that that's the person they really are and that's the person they will build upon, rather than this criminalised character that they felt presented as in court. And we can see all this has a huge impact from this quote from Grace, that she says, "The thing that made me actually want to prove myself was the judge, because I felt he didn't have to give me a chance. He's understood me a little bit. He's got to know me better. And that's built this level of trust with him. And so even though she might never see him again, he gave me a chance already. It allows you to be a better person." So it's not going to change everything for children. They need support post-sentence, absolutely. The structures, support into employment or education, mentoring, etc., etc. But this can be the starting point, the building, a foundational point on which those other building blocks can be placed. But I also think it's important that when judges focus on these elements of communication, focus on simplified language, understanding the child's communication needs, conveying to the child that they understand the difficulties they've had earlier in life, conveying to the child that they can see the good in the child, that might also change how the judge is thinking about what sentence to deliver. So if the judge has got all the information about the child and their communication, their disabilities, that may impact their assessment of the child's culpabilities. So there's a sense that there may be this relationship between the way that the sentence is communicated and what the sentence outcome is at the end. That it may, if judges have time to reflect on their sentencing remarks, or just going about this process of gathering as much information as possible and reflecting that back to the child, this may impact on what outcome they come to. So just as we get towards the end of this presentation, then I just want to finish off with some resources, some examples and some practice points. So the key resource really for sentence delivery is to be found in both the Sentencing Council guidelines, but also the Crown Court Compendium. Part 2 of the Crown Court Compendium focuses on sentencing, and within there is an appendix to which I wrote alongside Claire Parkinson and Kate Aubrey-Johnson about communicating sentences to children. And it includes a number of tables that can be useful checklists, and it sets out the kind of legal framework, the reasons why we want to focus on communication, and some kind of checkpoints of what judges should be thinking about. Also within that are examples of how to deliver specific sentences to children, such as a DTO, youth rehabilitation order, and so on and so forth. So just to pull out a few extracts there of these sort of example sentences, some of the things that we would want to do is to think about how timeframes are communicated. So if a judge is given a detention and training order and it's 30 months, the judge might want to say that's the same as 2.5 years. Or if it's 12 months, that's the same as 1 year. That will make that kind of time periods, thinking about that will help the child. Or explaining concepts such as if it's a sentence of detention for life, the child might switch off there and think they're never leaving prison. So explaining, using that term only once and explaining what it means, that it does mean the child can leave custody one day, and setting out how that might happen. We see examples that give simple explanations of either complex legal terms or often see reference to the parole board, so explaining who the parole board are. Again, we see numbers here. Half of 8 years is 4 years. So, and you might say in 4 years' time you will be, 19 years old. So that is meaningful for the child. And this is a real life example that I just want to draw on. Handed down in a very serious case. It was a manslaughter case. The diminished responsibility was used, and it was a manslaughter conviction. And this was a teenage girl, I think she was 14 or 15. And we see here that the judge divides his sentencing remarks into 3. So he sets out what the sentence is at the outset. So rather than the child's anxiety building during the delivery of the sentencing remarks, they're told straight away what their sentence is going to be. Then sets out the reasons in a way that the defendant, Kayla, and other interested parties, the victim's family, can understand, and then gives some more sort of legal reasons, to, I guess, the Court of Appeal version, if you like, I suppose. So he sets out he signposts and structures this, and he also says he'll give her a written copy of the remarks. That can be really important to request. The judge gives a written copy so that the child can reflect on it later on. We see timeframes explained in meaningful ways. We see complex legal terms being explained here in as simple a way as might be possible. We see the judge doing this kind of softer relational work in the sentencing remarks as well. So he talks about her having a heart and a future still worth living. He's demonstrating care, saying, I'm grateful for the letter you wrote, and if you want to write for me again, I'd be grateful to receive that. He shows he's taken the welfare factors into account and is displaying empathy. I know that you have had a terrible life up until now and have experienced things no one should have to. So it was a really powerful set of sentencing remarks. It was appealed by the Crown to the Court of Appeal, and it was appealed on the grounds of leniency. It was unsuccessful, and the sentence was upheld. And in the course of delivering their judgment, the Court of Appeal commended the judge on what they described as his careful and audience-sensitive articulation of the rationale behind the sentence that he passed. So this is endorsement from the Court of Appeal that this is a good way to deliver sentences to children. So just to finish up here on a few key takeaway points, I suppose. So some practice points for lawyers. So first of all, first and foremost, determine whether the child has any diagnosis or communication need and what support is needed for the child, and to communicate that to the court. Ensure that all relevant information has been obtained and provided to the court, including from the local authority, so a special educational needs assessment, any speech, language and communication needs, or other factors that are relevant to the child. Making sure that the child's had an opportunity to read the pre-sentence report before it's finalised. Of course, ascertaining the child's wishes in terms of participation. Do they want to talk, put their views to the court? How is that going to be facilitated in the courtroom? How well prepared, helping the child to prepare for what they might want to say, explaining to them what will happen, making sure that any adaptations to the courtroom are requested, making sure the child's sitting with a supporting adult. There are breaks where we can check their understanding. On a later slide I talk about intermediaries, but thinking during the sentencing hearing, do you need to request the presence of an intermediary who can assist the child during the sentencing hearing as well? Making sure you use language that you would wish the court to use. So we're in the courtroom, making sure that you're modelling that language to the judge. That can be quite impactful. Again, just to refer you to Table 2 of Appendix 2 of the Crown Court Compendium, which sets out a table of terms, so simple ways to explain more complex words and terms to children. And of course, referring, I think a lot of the courts will be familiar with ZA, but there is no harm in reminding them and reminding them that a root and branch difference of approach needs to be taken. There needs to be a different way of doing the sentencing hearing. The judge should take time to write their sentencing remarks in a way the child can understand, and request that the court use child-appropriate vocabulary and explanations as in the appendix. And, as I say, consider the use of the intermediary, not just during the hearing, but also next steps. So it might be possible to have a post-sentence conference with an intermediary who can use visual aids or easy read documents, or provide other resources that can help the child to understand not just the sentence, what it requires of them, though that is absolutely crucial to make sure they can comply with it, but also that the child, if there are positive things that the judge or the magistrate has said to the child that gives them hope and so on, that they can take those things with them as well. And, you as a lawyer, making sure the child understands. And then finally, requesting the court provide the child with a written copy of the remarks where possible, again for that later reflection. So I will end there. And just put up a couple of academic resources. So the research on which my presentation has been based, my own research. There is if you Google the kind of justice or me, and you will hopefully find also a short version, a practice guide on Newcastle University, where I used to work, on their website, if that's more accessible to you. Thank you very much.